कोर्ट प्रैक्टिस न्यूज में आपका
Hello.
Sean, you're audible very much. Yes.
Acha, I'm audible.
Yes.
Then I should start.
I'm just wondering who is there.
Not a minute.
I'm just checking with the host
Yes.
whether we need to wait or we can just start. I think we can start, Dr. Chauhan. I don't see any trouble on that. So, yeah, good evening all. And
Good evening, all. Whether I'm audible to everybody, but they will be muted, ne? So, I think in the drafting paper we are devising two methods. One is statutory appeals and other remedies, and the main is the constitutional remedies. As under the scheme of the Constitution of India, we have three types of jurisdictions. One is original jurisdiction, which is conferred by Article 32, 139A for transfer cases, and Article 131 for the center-state disputes and disputes between certain states and center. And the other jurisdiction is the appellate jurisdiction, which mostly we exercise, and 80 to 85% of litigation arose under this jurisdiction. And there is another third jurisdiction is reference. As nowadays you might be seeing, there is a controversy about the reference which has come to the Supreme Court on 23rd, I think, on 14th, I think. So these three jurisdictions, I think I am dealing precisely on the what should be covered in those jurisdictions in the drafting paper, and especially the writ jurisdiction, because under the scheme of the Constitution, the Supreme Court has power to issue writs state, and these writs are five, and these writs are habeas corpus writ, mandamus, prohibition, quo warranto, and certiorari. Mostly the writ which are exercised is mandamus and your certiorari. And this habeas corpus is also sometimes used, but that use is also very minimal, because you don't have many cases in that jurisdiction. In this jurisdiction, I have dealt important cases, because in 2005, the 11 MPs were expelled from the parliament. And one of those MPs, 10 MPs have filed their writ petition in High Court of Delhi. One of them has come to me at that time. In 2006, I filed a writ petition in the Supreme Court under Article 32. And the basic issue was whether the parliament has power to expel an MP, because the parliament has claimed its power to expel a member of parliament from Lok Sabha or Rajya Sabha under Article 105 of the Constitution. Under Article 105, Clause 3, the privileges which were available to the House of Commons of the United Kingdom, those privileges were inherited by our parliament. Though after the basic constitution, which was adopted in 1950, thereafter there has been two amendments, 42nd Amendment as well as 44th Amendment. These two amendments has omitted the reference to the House of Commons, but the basic issue or the basic principle which is available under the scheme of our Constitution is that the jurisdiction which was available on that particular day when 42nd or now the 44th Amendment was amended, by the Parliament under the constitutional scheme. On that day, whatever privileges were available to the Parliament or the legislature of the state, those privileges will continue to be available to the Parliament or the state legislature. The issue arose whether the Parliament has power to expel a MP, because personally in our constitution there is no provision which permit Parliament to take away membership of a member of the Parliament. This was an important aspect, because when I filed it in 2006, on the 2nd January 2006, I mentioned it before the then Chief Justice Sabharwal, the bench headed by Chief Justice Sabharwal, and the bench declined early hearing or urgent hearing of the matter. Thereafter, it was heard for admission on 15th of January. On 15th January, the court was of the view that this is an important question and we will consider in the Constitution bench, and it was referred directly to the Constitution bench. The issue which we are to deal in, suppose a client is coming to you, he was a member of Parliament, he has been expelled by the Parliament by claiming privileges. So there was a case earlier which was a reference of 1964 pertaining to the UP state legislature, where a journalist has approached the High Court because this UP state legislature, there was some article in his newspaper and he was author of that article, and the newspaper owner, they were the privileges were invoked against them, and they were summoned by the legislature. They approached the High Court of Allahabad, and 2 judges of the High Court has granted interim injunction. So they have stayed that warrant. So when the warrant was stayed, then the legislature has summoned those judges also as accused, like this journalist and the owner of the newspaper. Then thereafter, the reference has come to the Supreme Court, saying whether the High Court can intervene in such matters, whether these are issues of privileges, whether the privileges issue can be examined by the High Court or Supreme Court for that purpose. Then these issues were debated by the Supreme Court, and the incident came to know about after a lot of study on, because I was not expert of that subject, and incidentally that client has come, and at that time I was very young also, not having adequate knowledge about the parliamentary privileges and all these rights of the members of Parliament. Then we examined it. So I filed the writ petition and saying that this power is not available with the Parliament. If the Parliament is not having this power, then they cannot expel. So in Re Keshav Singh, if you go to that judgment at page 448, in the Supreme Court reporter that start at I think 413 and 448 is the relevant portion. Chief Justice Gajendra Gadkar has opined in that, and in that it was stated by the Supreme Court that there are certain privileges which are available in the House of Commons of the United Kingdom. But these privileges are not available in India, because we in our constitution has specifically dealt with certain powers and powers of the members, and their qualifications and their disqualifications are specifically dealt with under the scheme of the constitution. So the privileges can be claimed only if the specific provision is there under the scheme of the constitution. So this issue was there, and the jurisdiction which was claimed by the House of Commons in the United Kingdom was that that House of Commons has the privilege to constitute itself, and the power of constitution is not an unspecified power in our constitutional scheme, because this power, the qualification of members is specified under Article 84 of the Constitution, and the disqualification of a member is also specified under Article 102 of the Constitution of India. And this expulsion is not one of the disqualification as provided. The Parliament has enacted a legislation which is known as Representation of the People Act. In that also, this Article 102 1E of the Constitution, and for enacting this provision, the Parliament has invoked this power and enacted Representation of the People Act 1951, and the qualification and disqualifications are specified in this also. If you go to this act, then qualifications are specified in section 4. Section 3 is for Council of States. For House of People, it is section 4, and likewise disqualifications for Legislative Assembly in section 5, for Legislative Assembly of Sikkim, section 5A, and likewise there are provisions of disqualification, section 8 on conviction of certain offences. So this was a power which was to be exercised by the legislature. If in exercise of this power, legislature has provided that a member can also be disqualified by way of, and this power can be exercised by the legislature. But since in our constitution, we have specifically dealt with the powers and the privileges, and the privileges are available if it is not specifically covered by the Constitution. Constitution has itself stipulated certain parameters. So if a member is coming, we have to examine that whether this power is available. So today a member is coming to you, then because thereafter the case was decided, that was Rajaram Pal versus Honorable Speaker Lok Sabha. This case was decided and reported in 2007, 3 SCC 184. This is also reported in SCR and other journals also. So the majority has taken a view that the Parliament has privilege of expulsion. But the minority judgment delivered by Justice, the majority was delivered by Chief Justice Sabharwal and Justice, two other judgments, and this the dissenting judgment was by Justice Ravindran. Justice Ravindran has examined this aspect and has taken a view that this power is not available in India, this power of expulsion. But now a member is coming to you, now that Rajaram Pal case is also there, which is decided by the Constitution bench. But a member is coming to you and telling that you draft a writ petition. Then your writ petition should contain that this Rajaram Pal judgment is 5 judges, and Re Keshav Singh, that was the reference, and the Constitutional Article 143, the Supreme Court has given opinion, that is by 5 judges, 4-1, that is the decision. So your petition should contain that since the 7 judges principle has not been respected by the Constitution bench, that's why you have right to approach the Supreme Court directly under Article 32, and this is one of the main principle, because if a larger bench has decided a particular issue, so that issue cannot be upset by a smaller bench. There are many cases. I have dealt with other cases also, like in another aspect, I considered a case against the correctness of M. Nagaraj case. And in 2015, I argued before a bench headed by Chief Justice Deepak Misra. At that time, he was number 4 judge, and Justice P.C. Pant, and argued that this Nagaraj is incorrectly decided. Though they have agreed, but they said that we have applied this principle in 9 cases, I think, and that's why we are not going to reopen it, and it was closed. Then again, the cases came before Justice Kurian Joseph and Justice Bhanumati. Then again we raised that issue, and that bench was convinced that since the Indra Sani case is by 9 judges, so if that principle has not been adhered by a smaller bench of 5 judges, then it should be referred to a larger bench. And the Constitution Bench, Jarnail Singh versus Lakshmi Narayan Gupta in 2018, 1810 SCC 396, I think is the citation, has decided that Nagaraj is incorrectly decided, and this portion of the judgment will not be read, whichever we were arguing that the social backwardness criteria will not be applicable to the scheduled caste and scheduled tribe. So if such a principle is there and a client is coming to you, then you can file a petition. In that petition, you can take a ground that since the law is not settled, because larger bench is saying something differently, and the smaller bench, or the Constitution Bench, or still a smaller bench is saying something different, then you can raise an issue that the constitutional interpretation has to be settled. And for this, you can file a writ petition. And you, in which writ you will claim, that is also an important issue, because we have discussed there are 5 kinds of writs. So in this, you will go for writ of certiorari, because the orders which are passed by the Speaker of the Lok Sabha or the Lok Sabha Secretariat, you will be going for questioning it or setting aside that order, so by issuing appropriate writ of certiorari. But suppose you want some direction also, then you have to file a writ of mandamus, because the direction can be issued in that particular writ. And if somebody is say not available, then in that case you have to file a writ of habeas, because there are many kind of writs. This is in a way I am explaining that that is an important case you must understand, and I feel that every advocate must have a case of a member of parliament, because that is the power or right which you have to exercise in the Supreme Court, because the rights of determination of the power of the parliament is one of the important aspects, though that can be tested also in the when you are challenging the virus of a particular statute before the court. It may be Supreme Court or it can be the High Court. So that is also a thing. But I think you, in such cases where you are going before the court, and in addition to this, there are certain parameters in the drafting, because like in Supreme Court, how to address the court, that is also you have to examine and you have to decide, like to the Honorable Chief Justice and his honorable companion justices of the Supreme Court of India, that type of phrase is there, or in which article you are filing it, then you have to mention that also. So all these things will have a separate marks, and in the end we have, and for this act of kindness your humble petitioner shall and for this act of kindness your humble petitioner shall ever pray. That type of phrase is there. So every examiner who is deciding, who is evaluating your paper, will consider the basic things which should be contained in a petition, and these formats which should be part of your pleading, that must be there. And the basic grounds which you have to take, or the question of law which you should incorporate in your petition, that must be there. Only 2-3 questions of law you can put, only 2-3 ground you can put, because time will be very less for attempting that question paper. Question paper itself is likely to be very lengthy. So if you are attempting that question paper, your answer should be crisp, but it should be to the point. Whatever is asked by the examiner in the question paper, that should be attempted. And extra things you should not add to your answer, because there is a system of evaluation, and in that system we will be giving you marks if we have the opportunity of evaluating it as per a pro forma, like 2 marks for title, 2 marks for preliminaries, 2 marks for additional things, and how it is to be addressed and how prayer is to be made. Normally we have format of prayers, but in writ petition that format will not work. You have to draft the prayer in such a way that whatever you are praying from the court, like if you are praying for certiorari and for quashing of a order passed by the parliament, in this case under 32, then your prayer must contain for issuing of appropriate writ, writ in the nature of certiorari or any other appropriate writ, quashing so-and-so notification issued by so-and-so, and date, etc., everything, or annexure number you can include in that, because everything contain marks. Your marks will depend on how you are attempting, and all the major principles which should be there, that should be part of your answer sheets. So I think the remaining Mr. Baruka should continue, and 20 minutes we have divided. I think I have spoken for 20 minutes. Thank you.
No idea where the host is. Thank you. Right. Thank you, Dr. Chauhan. Good evening, everyone. Yes, this is a drafting lecture. I was seeing a bit of these comments in the chat box. So this is for the purposes of drafting paper. This is paper 2. Now, drafting, as we understand, drafting is like an umbrella, and it subsumes all these subjects. We should remember that. When you are drafting a specially petition or a writ petition or an application or any pleading for the Honorable Supreme Court, you would require the knowledge of Supreme Court rules. You would require the knowledge of the relevant constitutional and statutory provisions. So the entire practice procedure comes in. You would require the knowledge of the relevant case laws which might be relevant for the purposes of that particular pleading. So leading cases, case laws also get subsumed. And your drafting should be based on ethical principles. So even ethics comes in. So like you cannot really make a false statement. You cannot mislead the court by your drafting, by the brief which you're preparing and filing in the court. So number one is your drafting is extremely crucial because this subject kind of pulls in all the other subjects into itself. As an advocate on record, when you are drafting anything for filing in Supreme Court, you are expected to have a larger knowledge of all these. That's first part. Second, what you must always remember is that drafting should be persuasive and compelling. As an advocate on record or as an aspiring AOR of the Supreme Court, you must realize that it is your drafting of the pleading which reaches an honorable judge first before you reach and make your oral submissions. Your draft should be crisp and clear. It should reflect due application of mind on both facts and law. And it is this drafting which is really the first introduction of your case and of your client to the judge. So if it is not clear, it is not in a way logical, if it does not cover the relevant judgments or the provisions, then the draft is of no good. So you have to be very careful when you are drafting on these lines. In terms of the paper format, there has been a slight change this time. You will find that there is part A and part B. Part A would contain certain number of questions and there will be options. Part B would also have certain number of questions with options. So there would be some optional questions you will have. So you'll have some breather, and to understand that how things progress, you will have 30 minutes extra to read the question paper. So rest assured, you should take the best of those 30 minutes, carefully go through the entire question paper, assess which questions you would like to attempt, and pick up those before you start writing. There's another slight change of format, which you will find slightly different from the earlier questions. There is no real indication of what you need to draft. And this is really based on the premise that if a client is coming to you and telling you of the problems, that this is where my problem is, this is the case, or this is the judgment, or this is where the issues are. As an advocate on record of Supreme Court, you are expected to analyze and then assess as to what has to be filed in Supreme Court. The client would not be telling you that this is the pleading to be filed. So this is another parameter which we would want to test you, that you are aware of the Supreme Court rules, you are aware of the constitutional and statutory provisions, and you are able to pinpoint as to what you need to file based on the factual question which would be there before you. So it could be a judgment, it could be some factual scenario. If suppose there are a whole bunch of multiple applications to be filed under Supreme Court rules, so a certain factual scenario would be given, you will have to find out what you need to plead. And this is extremely crucial, because if you draft something which is completely erroneous, then howsoever good your ground is or the question of law is, that would not help you. Because if you file that in Supreme Court, obviously your client will not get the benefit. So be very careful in reading the question papers and to assess what exactly you want to do. And we believe, as part of the examiners, we believe that if any practitioner, a regular practitioner in Supreme Court who has taken his training seriously of 1 year, he or she would not have a trouble in pinpointing what needs to be filed. So that's very important change of format, which you will realize. Then next, on the first page, we have given general instructions. Please go through those general instructions very carefully. That's why those 30 minutes are given. And that would reflect that what's the approach we are attempting in this particular examination. We are not looking at quantity of the pleading. We don't want number of pages after pages. We are looking out for quality of the pleadings, one. Number two, what we are looking out is that if you give more references to the relevant judgments or to the statutory provisions, that would obviously attract more marks, and that would be appreciable. Also, what we have done is, realizing that many times the question papers are extremely lengthy, we have specifically given under every question what is required out of you. Let's take an instance. There could be a question which says, okay, please draft only the synopsis and the grounds and the prayer. So you need not draft the list of dates. We are surely not asking you to draft or build up the cover page or anything of that kind. But then it will be equally important that if you are asking for synopsis and questions of law and prayer, it means that we would want you to analyze that very carefully and build up your synopsis strongly. It should be compelling and persuasive. That itself should contain your most relevant grounds. It should contain your provisions of law or the judgments or anything else you believe on the basis of facts, which whenever an honorable judge is reading, he is actually persuaded by your entire arguments. Because as I said, drafting is the first brush of the court with respect to your client and your matter. So if there has to be a synopsis, it has to be extremely very crisp. any general grounds being built up, general questions of law, whether the Honorable High Court has erred in law and fact, or because it is erred, that would not really help. We would want specific grounds, specific fact-based and law-based questions of law. All this is a part of the instructions. I'm effectively just giving you an overview of the instructions which is already there. So please go through the question paper very, very carefully so that you are able to understand what exactly you have been asked for. As I said, there are two parts to it. There will be multiple sort of, there'll be options. You'll have enough options, but it's just that the more you would have prepared yourself with it, the more you would have done your drafting yourself as an advocate, especially through the training period, the more it will be easier for you to be able to really pinpoint what you need to file. So this really is more or less is what I had in mind. There's one short, I would say a write-up. There is a book by name, Writing and Analysis in Law of 1999. There is a chapter, Effective Paragraphs. Now I'm just sharing a link of it only in case you people have time, because I know you all are hard pressed with the huge work. In case you get some time at some point of time, just to read through it around 20 pages. I have used it heavily when I was in AOR for 18 years. I used to read it regularly because that gives me that crispness in terms of how to really build up your paragraphs, how to connect one paragraph with the other and make it a logical flow. So that's something which sort of helped me a lot. This is not only for the exam, it's just generally even otherwise. So what I'll do is I'll just share a link, and this link will be available till tomorrow. I'm just putting it in the chat box. I see a lot of people have been asking. So I'll just put this link of this particular paragraph in the chat box. Please download it. And if it is help just in building up your own skills of drafting, that would be good. I just shared that. It's the book name is Writing and Analysis in Law. It's a 1999 book, and the chapter is Effective Paragraphs. So I've just shared that. So one can have a look at this, and yeah, any questions, please feel free to ask. You can put in the chat box, and Dr. Chauhan and I, we both can we both can respond to it. So any questions, please go ahead. Affidavit exempted. As I said, you have to attempt only what you have been asked for. Every question is clearly indicated what you need to put. So don't say anything beyond that. You don't need to put it. We have been very careful. We understand the difficulty. So every question, some question may require affidavit, some may not. Some may require certificate, others may not. So that's something which you'll have to look at the question paper. What kind of applications? All kinds under the Supreme Court rules. Certificate affidavit, I've already answered. Memorize the citations, provisions will be provided in the question paper. So it's a mix. Somewhere provisions are provided, but I would suggest that please be very, very clear about the Supreme Court rules. That will help you a lot. We'll probably expect a lot from because it's a part of the practice procedure anyway. So that's something which would help. Will we have 20 mark questions in the last time? Yes, there would be. How will be the pattern? I've just indicated part A and part B. Part A is the main questions, the big questions. Part B will be the smaller questions. Appropriate court fees. You'll have to see. It depends upon what has been asked for in the question paper. How much are we expected to write? Any brief idea? So even in terms of how many questions of law and grounds, that is also indicated in the question paper. Every question has its own independent requirement. So in terms of number of questions of law, number of grounds, that also is indicated. You'll have to also assess somebody there is no indication, and if it's a big question mark, then you would be expected to write a bit more than those limited number. But again, as I said, quality is important. If you keep just adding on and on questions of laws and grounds, that won't really help. You may mention part A, which is the difference in the kind of questions in both. So part A is the larger questions, more marks. Part B would be the smaller ones, applications, etc. There's no marking scheme and distribution. Okay, so part A is actually 20 marks each question, and part B are 5 marks. Develop on facts on which questions are silent. Yeah, of course, you'll have to just assess. As I said, act like an advocate of Supreme Court where you are filing a particular petition. There is nothing specific about it. It has to be only law or only facts. Depending upon the facts, there could be some questions which are fact-based. You might just want to sort of see a bit of law if it's required. So whatever is applicable. Examples of questions, I think that's something you can pick it up from the earlier formats. But as I said, only thing is that we haven't really indicated what you have to draft. That you need to assess for yourself. Best points to draft a polished synopsis. So see, as I said, synopsis is something which should be compelling. So you'll have to indicate that if there's a certain judgment which has come forth and you believe that, and see, normally wherever we have asked for a synopsis, we have not asked for grounds. In which situation we do expect the best of your grounds which attract the attention of the judge should be placed over there. So you need to be very careful on that and make sure that all your relevant grounds is then clearly put in the synopsis. But I think the way of putting a synopsis is it should really flow well logically so that by the end of it, one is convinced of what exactly you want to argue. Pattern of questions, marks distribution, I've already indicated. How many questions and so part will be required to be answered detailed way. Yeah, both parts are mandatory, but as you will see, part 2 is a bit light. Part A is the heavy one. How many questions of law grounds? Again, every question is indicate very carefully. There is nothing like a minimum how many grounds. So manage time for completion. I'll suggest that please make the best of those 30 minutes, carefully go through the question paper. And I'm repeating, please very, very carefully go through the instructions. There are first general instructions on the first page, and then there are instructions at the end of every question. And that will give you much clarity in terms of the questions now you're asking. Referring to judgments in draft mandatory, it's preferable. Again, the general instructions on the first page indicate that the provisions of law and relevant judgments, they would be appreciated if that is placed. As I said, drafting subsumes all the subjects together really at one place. So the more you are able to reflect upon the question and you are then able to answer it appropriately with the provisions of law and judgment, the better it is. If any question simply says draft petition, does it include synopsis, LODs, and affidavits? I think all the questions would be more specific than that. I don't see any reason for being concerned about that. So I think every question clearly indicates what we want. There would not be such kind of a very general question, draft petition and full stop. So the format doesn't really matter in the sense you will note that we are not looking at the format, we are looking at substance. So you should look more at the writing in terms of the facts of the case or the questions of law being raised. So substance is something we are clearly looking at. Any particular statute that we should be focusing on? No, so I think over there, what you need to really see that, again, I think it's a matter of practice procedure when you know all the kind of various jurisdictions you get. So all those relevant statutes concerning those various jurisdictions, that's something you'll have to suppose criminal appeal or civil appeal or other areas. So as I said, if you have gone through a single round of practice procedure during your preparations, then you should be able to cover the drafting because then you would know that it's really arising from those. At the end of it is Supreme Court jurisdiction. So we know which all statutes cover Supreme Court jurisdiction or the constitutional provisions. So the drafting is bound to come from those areas. Again, the format, etc. of the writ petition, I don't think you have to really worry about. Each question is very, very specific. No, there are 20 marks question. There are no 40 marks question. Is statutory appeal expected? I don't know. It's all part of the Supreme Court jurisdiction, so you will have to keep that in mind. We write synopsis in half page being concise. You see, it all depends upon fact to fact. Sometimes you're right, if you're doing a bail matter, 4-liner synopsis might actually help and be effective. But I think with the questions we have built up, and as I'm saying, wherever there are synopsis being asked, you will notice that grounds are not being asked. So we do expect that your best of the grounds are incorporated in the synopsis so that we get a feel of how you have really built up your case. You see, at the end of it, you have to realize that you should be able to indicate that you have understood the question, you have applied your mind, and then you're able to reflect yourself through the writing process. That's what drafting is about. You should be able to reflect. It's not that you draft something and then you go to court and go for oral submissions. But here, in order to get through with this examination, your drafting skills, your expression through writing is what is most critical. So that's something which you need to really keep in mind. Patient groups. See, generally also, I just saw somebody saying that if case demands, comprehensive drafting should still be made first. There is no specific formula to synopsis. You should yourself be able to convince that, okay, what I have read the synopsis would be enough for the honorable judge to appreciate your case and to be able to take forward, so that by the time you come for oral submissions, you do not say a word. You're effectively introducing your client and your case to the honorable judge through a synopsis. In case only ground prayer is asked, so we have answered directly or write in the petition format. No, if there is only ground in prayer, please give only grounds in prayer. No petition format is required. As I said, read through the questions carefully. At least there we have been very careful not to overburden you with something which is not required at this stage. We want to assess how qualitatively you are able to build up your case. So if somebody says draft the grounds and the prayer, that is all what is required. You write grounds, build up ABCD. You say prayer, write ABCD, and that's it. You don't have to go beyond that. Somebody is asking again about the formats. Please don't worry about the formats. You will see in the question paper that it's a different way of looking at it. So no, don't underline or bold or do, don't do, just write a simple one, because if you are very sure about what you are writing, that is more important. We will anyway be reading each and every word. Okay, they are like almost more than 200-300 questions. So I've indicated the format, part A, part B. Part A would also have options, part B will also have options. I think there was one question probably which was relevant. In case we go ahead with a SLP instead of a statutory appeal, when actually statutory appeal was to be drafted, but grounds so and so spirit, would it lead to no marks in the question? Quite probably. I think that's where we are also very trying to actually assess whether you are able to pick up the correct format. If you are required to file a statutory appeal and you end up filing a SLP civil, that won't be accepted by Supreme Court. And when I'm saying accepted, I really mean is that in terms of the registry itself. So when you are filing something, we also expect that it should be at least in terms of not only the constitutional and statutory provision, in terms of the Supreme Court rules. So that's why I'm again repeating myself. Please be very careful, read the instructions very, very carefully. Make sure you do not make such a fundamental error as preparing a SLP civil instead of a civil appeal. Okay, so any specific drafts? Okay, so to give an idea about the marks, because I think a lot of people have been asking about how things are. So part A would have, you'll have to have attempt 4 questions, 20 marks each, and part B would be also 4 questions, 5 marks each. Again, about the counter, rejoinder, etc. Everything is quite categorically given instructions in the question paper itself. I think to my understanding, we've kind of covered the entire issue. At the cost of repetition, please read instructions, all of them. You have 30 minutes extra, and focus on the quality of your pleading, your drafting. Be very careful in terms of what you are preparing, what you are drafting. Some of the questions you have to be very careful in terms of assessing first under the Supreme Court rules what you are supposed to draft before you make an attempt to draft. See, in terms of an idea of what would be there, I think, as I said, there are options available. So if you are a regular practitioner in Supreme Court and you have undergone a training, then that's something you'll be able to assess well. It will not be fair on me really to indicate that what kind of draftings are likely to come, because again, this is change of format. You will have to find out what you need to draft. The question is there, this is a problem you have, this is the factual scenario, there is a judgment or there may not be a judgment. You will have to find out, you will have to decide what to draft. So that's a call which you have to take based upon the facts and the questions available. So cost title, etc., that is also indicated wherever is required. Whatever is required, just draft only that. Because that's again the reason is that we don't want you to overburden with all those additional. Wherever we believe a cost title is to be done, it is written over there. I think that is all from my side. Dr. Chauhan, if he would like to add something else. And thank you so much and best of luck to all.
So, thank you, Bharukaji. I think I have also spoken whatever I wanted to speak. And in addition, the part B is also compulsory. That I want to stress. Because the first part will have 4 questions and the second part will have 1 question practically, but it is divided in parts. This, I think, thanks.
Right. Okay. Thank you all and best of luck to everyone.
Thank you. Best of luck.
So how much do you earn?
42 lakhs per annum.
42 lakhs. That is your salary.
Yes.
What do you do?
I am an AI tools and ChatGPT expert.
Okay. What degree did you pursue to become that?
Well, honestly, I didn't need to do any degree for it. Nor did I spend any lakhs of rupees for any program.
Okay, so if someone wants to earn the same package as yours, 42 lakhs per annum, and also become an AI tools and ChatGPT expert, what do they have to do?
They can simply attend T10 Access 3 hours AI tools and ChatGPT workshop, which is conducted by IITians. Here you get to learn how to create any presentation under 5 minutes, do any kind of IT work under 10 minutes, learn and apply 100 plus Excel formulas without remembering even single one of them, and automate up to 95% of your work with the help of AI. Yes, and you get to learn all of this for just rupees 9. So anyone who wants to master AI and ChatGPT and wants to grow in their career should definitely sign up for this workshop. But book soon, as they usually have limited seats.
Good evening to all of you. When I enter the Supreme Court, gush of memories, because I was born here, in the sense that right from the first day of practice, I've been here only. And so when I was asked to come and speak for this lecture series, and that too on practice and procedure, I had to accept it because this is my, what you call as, in the profession, my Janmabhoomi and my Karmabhoomi as an on record. 19 years as an on record here. Now, I'm told this is a part of a lecture series for